G'day, Kim.
Hi, Andrew.
Trembling?
I am a bit. I know how much I love this. Anyway, but it's a very exciting day for our beautiful Nina.
It is.
She's getting married.
Isn't that just
So,
wonderful?
Unfortunately, you're stuck with me for the next 3 weeks while
Well,
Nina's off having
we're
a
all lucky there
wonderful time.
too. So it's a win-win, really, isn't it? Kim's masterclass on workers' comp has taken off, so we've had to go to a bigger venue.
It's filled up.
Yeah, so we'll put the thing on at the end, which tells you where to do and how to get there. But please come along. We now have a much bigger venue, and
we can
Kim's
double our numbers.
shitting herself now with. Sorry, it's a big night last night. She's going to be more scared, more people there. So if you want to see her really scared, keep coming.
Yeah.
The other issue is today we are going to talk about the liabilities and risks for OHS and HR managers, and not just in the prosecutorial sense, but in the general protection sense today. So we've got a really long case study, which I drafted potentially hungover, but it is longer, quite longer, deliberately to flesh out where the risk sits and to show you where the points where people require and ask you to do things moves from being wrong-headed to unlawful. Okay, so bear with us. We are going to spend a bit of time on it, but we've had a fantastic reaction on LinkedIn from the HR and OHS managers who are saying, yeah, please talk about this. So we're going to spend a bit more time, and I've jettisoned a couple of cases which aren't so exciting, okay? But look, I thought, Kim, let's get stuck into hybrid building as our first case.
Okay. So this is a application under Section 120 of the Fair Work Act to reduce redundancy payments.
So can we just understand, when you transfer someone from, you're doing a restructure and you go to move someone from one business to another associate or to another job, it has to be substantially the same job.
Yeah.
And if you do that and the person says, no, bugger you, it's not the same job, and says, I'm out of here and want a redundancy, you can go to reduce your redundancy. You can't just not pay them. I just thought I'd say that up front. Yeah, off you go now.
So you can apply to the Commission to reduce the payment if you offer acceptable alternative employment or if you can't pay. So they're the two criteria in the legislation. In this case, hybrid building sought to move a project manager to an associate business into a completely different role, business development role, which he had no skills or experience. And he rejected the offer on that basis. So they applied to the Commission not to pay him because they'd offered him suitable alternative employment, and they also said they couldn't pay.
And suitable alternative employment means it must be substantially the same.
Yeah.
And that looks both towards money, nature of role, and the nature of retraining, if any, that would be required. So they're the factors we go to.
Yeah.
So what do they say here?
Well, the Commission said no, it's not substantially
it's
the
absolute
same
bullshit.
role.
They said
and also you can pay because the associate entity was able to pay even though the building company could not potentially.
Okay, so anyway, let's jump on to the next case, because I think we see a really interesting one when we come to barter card.
Yes.
Can I say barter card's fascinating because we hear all the bad news about working from home. And here's a case where an employer thoughtfully worked about what would work best for them in the organisation. This is quite a large cost saving internally in the business for overheads, but interesting set of facts.
Yeah, so restructured the business to get people out of the office working from home. There were 5 employees. They all said, no, don't want to work from home. So they rejected the redundancy. And it was the same argument in terms of, is it suitable alternative employment?
But they also got more money.
Yeah, they got more money.
Not only that, they ran the bogus argument saying, well, I'm not going to get enough to set up my home office.
Yeah, and it's a demotion. So they lost a vehicle allowance, but they got other incentives. So they had more than enough to cover it anyway.
Yeah.
But it was interesting because the Commission looked at each of them individually, looked at their own home setup and made a decision based on that. And so, yes, there was some reduction in the redundancy pay, but it was very minimal.
Yeah, so
because they were satisfied.
I think it's really interesting to show, and what Kim says is right. It goes to each individual circumstance when you do these things. So it is a relevant matter. But the other issue is we use these two cases to demonstrate. Don't try and be too smart, in my father's saying, which I keep repeating. Don't try and be too smart by half to get out of redundancy. You're going to employ a lawyer to go down to the Fair Work Commission. You're going to spend that money very quickly, and then you're going to lose in any event. But if your facts are right, you can ring Kim and check, maybe get her to draft a letter submission, maybe $1,000 or $2,000. Go and do it yourself. Give it a run.
Yeah.
Because if you're confident that you've done everything and you've documented it correctly, and Kim will tell you how to do that, then you are going to save yourself 10 or 15 grand, and it's worth doing. But you do it yourself. You don't always have to go with a lawyer to the Fair Work Commission, because this is just pure fact. It's not law, pure fact.
Fact about the job.
Yeah, and the person
And-
involved.
yeah.
Okay, well, look, that's good. Let's jump on to your next case. The discrimination. I think we should talk about this briefly before you hit the case.
Yeah.
15 or 20 years ago, sexual harassment in all forms was not condoned, but it wasn't overly criticised. So if you patted someone on the bum as you went past, or you made some sexual connotations, you might get away without even a warning 20 years ago. And that's around about it's before then when I started in workplace law. But for the first 10 or 15 years of my law as a workplace practitioner, and I've only ever acted for employers, I'd say, yeah, look, that's bad. We need to counsel. We need to set up some training. We need a proper apology. That's not the way it is now, is it, Kim?
No.
Which is a good thing,
I was very pleased to read this case, I must say, because we've got a very long-term standing employee, 20 years of service, one-off incident where he touched a woman on the bottom, in an intimate spot on her bottom.
Yeah, not just touched the bottom, but
no. They investigated, terminated. He went for an unfair dismissal. Termination was upheld on the basis of what he did. But you've just got to be aware of the vicarious liability issue for employers as well, to make sure that you do have a proper policy in place and you do provide regular training to your staff about the risks of sexual harassment, that it won't be tolerated, and if you are prosecuted, we won't be liable.
Yeah, we're not going to indemnify someone who does it. I think one of the issues that Kim raises, which I think is really important, is there are some no-go zones. You know, we used to call them in safety golden rules, things that you do this, you're out. I think now with the positive duties and the cultural phenomena of what we actually think as a community now about these things, isn't it right that we say this is a golden rule? Isn't it right we say, look, we just won't tolerate it, and we're going to stay in your job after you do it, there's got to be some compelling reason, because you've damaged someone.
Yeah.
And I think I've said in a couple of articles I wrote, I don't understand people who go out of their way to harm someone for their own benefit or for money. People like that are not good people. Why wouldn't we adopt that? Why wouldn't we say that to ourselves? When a person does that to a woman, he knows it's unwelcome. So
she will not feel safe working with him ever again.
That's right.
And so they have to take that into account.
I know, but he knows when he does it, it's not welcome. So he knows he's harming this woman. He's using a particular power as a big bloke wandering past. He knows he's harming. And I just think that's shocking.
Yeah.
Anyway, look, that's me on my hobby voice. But
right.
I think it's a
good case. Really,
and I think what it shows going forward for all of us really is that the world has changed, and it's great.
Yeah.
You know, with my 4 daughters, it makes me feel a lot better the world's thinking that. All right, well, let's swap over to what will be our main theme. I'm only going to do a case that's just come out, and we'll go to our main theme a bit afterwards. This is the Din Tai Fung case.
Hang on, you're missing one.
I don't think I am. It's Din Tai Fung. No, it's the order in which it comes. So that's why.
You haven't got that safety case.
No, that's all right. Safety case has dropped out.
The safety case.
No, the safety case is next. I promise you. I've got the running sheet.
All right.
You trust me. I put Din Tai Fung in before we got to the major theme for a really good reason, and that is I want to highlight what the courts currently think right at this moment, only a week ago. And then I will go back and we'll deal with the older cases in the major theme, okay? Din Tai Fung was a case where the manager and the HR manager effectively determined that they weren't going to pay people if they worked over 76 hours, any leave entitlements. They took advantage of migrant and temp workers. It was an horrendous scheme that was prosecuted. And it was deliberate. And the HR manager in this case was not someone who was reluctant to be involved, but willingly participated in falsifying records, doing all sorts of things. End up with a $100,000 personal fine. Business, I think, got $4 million in total penalties.
Yeah.
I raise it now because this is the extreme. So I want to take you to where the extreme is. This is a complicit HR manager who participates in decisions knowing it's wrong, sets up a touch screen finger that draws in when people come and leave, has to enter that physically into a spreadsheet and directs the person who enters it to never go over 76 hours. Outrageous stuff.
Terrible.
But a $100,000 fine and never be able to be employed again type name afterwards, it's a big penalty. I don't think any one of the people who are listening today would ever contemplate that. So I'm putting it on before we get to the main topic.
Okay.
So you can see, I'm not saying anyone could do this, but when we get to the main topic, you'll start to see things where you do feel uncomfortable and you've been asked to do things before or not done things and gone, oh, I should have done this. So coming back to that, let's go on to the safety case.
Okay.
Okay. this is a really interesting case. The facts that sit behind this, and I'm just going to have to.
No, I can
You can do.
So we had a truck driver was hit by a forklift whilst unloading and assisting it.
And there'd already been a 2017 incident.
Exactly.
That's right. And what happened in this is the director was a guy who was interested in safety. He had them as regular reports. He followed through. He was interested in safety and showed a genuine desire. Now, he was personally charged as the director under his due diligence, Section 27 obligation. I told Kim occasionally I'd blank out, so there you go.
Yeah.
Just did. Section 27 obligation of due diligence. And the court said, look, the company is undoubtedly liable, okay? This
didn't have a traffic management
didn't have traffic management system, despite the warnings they had in 2017. But he has done everything he's obliged to do under Section 27. He's taken interest in the law. He was satisfied they did have plans and things in place.
Yeah.
He was satisfied that action was being done. So they had a 3-metre rule around the forklifts, but it wasn't being honoured. He couldn't see that, but he was satisfied from the information he received that work was being done on safety and it was good. Now, you see the point about this? We're now starting to see how officers can control the knowledge they receive to be safe. Okay? And I don't want places to be unsafe, but I do want our officer clients to go, well, what is the minimum viable product I need to know that I'm safe every day? And the answer is take an active knowledge and safety, build reports that advise you as to competence, capability and the enforcement of safety systems, give adequate resource, all the things you do.
And they're simple steps.
Yeah.
Aren't they really?
But tragically, we've got to understand that nearly all industrial manslaughters come from motorised plant in Australia. So of all 13, I think, that have been charged, all of them are from movable plant.
Yeah.
And nearly all of them involve traffic management. So if you really want to go to jail for a long time, not focusing on the low-hanging fruit, traffic management's the mistake.
Yeah.
All right, well, let's jump over to the main topic, okay? Now, what I thought I'd do first is I'd go through some older cases. So I'll go through Bever first. So I might get at the next slide if we can jump onto it. We mightn't have slides here for those. So didn't I do that? God, I'm a bum, aren't I? So look, I'll read. So AW in Bever is a case that was about a pizza place. And a woman who worked there was given aggressive and racist remarks about her. Terribly distressed, went home, told her husband. HR manager rang up to try and fix everything up. Husband got on the phone, explained it and said they're going to go to the Fair Work. And the HR manager thought, well, I'll take that as a resignation. Yeah, that's okay by me. It's resignation. And of course, it wasn't a resignation. Now, the case didn't end up having the HR manager being, there it is, look, it's turned up. Seb, you are a star. Didn't end up having a liability question that sat around the HR manager. But what I want to say is very well could have. And modern plaintiff lawyers would definitely have added the HR manager to this process of treating someone adversely as a result of making a complaint. Does that make sense? So this is a case that shows where HR managers are complicit in behaviour that relates to a protected attribute or a workplace right. They will be named. Discrimination lawyers have been doing it forever and a day, but they are a specialised group. We've now got general plaintiff-based firms who will do this very happily. Yeah. So let's move on. I'm just giving you a heads up on that. Probably the cases, if we can go to the next case, please, Seb. So this is Balderstone. Balderstone was a case of a guy who was the HSR on site of a building company. They wanted to move him off to salary. The CFMEU got pretty distressed about all of that. But what they really wanted to do is to roll up his wages and to move him outside of where he was. It was clearly a freedom of association issue. In other words, his right to be involved in a union. 2 HR managers were involved in it, along with a manager, and both were named and shamed, the HR managers, and both were fined. Okay, and you can, I'm not giving you their names, but you can Google the case and you'll find their names like every subsequent employer will do forever and a day. Yeah. Fines weren't large. I think they're about $4,000 and $10,000 at the end of the day. They weren't huge fines. But I want you to know when you're named and prosecuted, it's your brand. And here was something that the organisation wanted to do that the HR manager was involved in through sleight of hand and said, look, I didn't understand the legal effect of what I did and all that sort of stuff. But the bottom line is they just looked there and said, but you did it. you try to get around the award. So there you go. Next case. All right, Centennial Finance. This is the original case. Okay, this is where a business got in a bit of financial difficulty, tried to engage people as contractors, even some of whom were originally employees, had some free training that they undertook, which they didn't get paid for, was necessary for them, which clearly should have been paid for. The manager wanted this to happen because of the financial stress they're under. The HR manager said, I didn't know the legal impact of what I was doing, but quite clearly ought to have known it given her role as an HR manager. This is the case that sets HR as a good and a bad side. What it shows is HR and safety managers are now a profession. So they are assumed to have a body of knowledge. And the courts will go to that body of knowledge, and you can't plead ignorance in it. And in this case, she was found guilty of accessorial liability to the actual organisation. But it was such a dumb thing for her to do. And she did it because she was trying to please a boss. That's the truth. So whenever you think about issues of, I'm not sure what the law is, but doesn't smell right, ring Kim. Don't do it, And you are a professional now. So if you do it, you are going to stand alone and be liable for it. And that's what I want you to understand from this. You are assumed to have a body of knowledge about the area you practice in, just like lawyers are. Okay, let's swing to the last case. Okay, Fair Work. I think that's the second last case, not the last case. Yeah, I do know that case. I just read it about 7 seconds ago. So bearing with me just a second, this is another payroll issue. Okay. This is a restaurant in Sydney where there was direction to falsify records again by the HR manager. And again, they were found liable. So very simple case. I don't know if the safety case is in here I was going to talk about. So the safety case I was going to talk about is the case where we'd go to the case study actually, but I'll just keep talking. There's been a couple of cases where safety practitioners have been found liable, and it is where their body of knowledge sitting around safety is drawn to an issue. There's a recognition that they should do something and they choose not to do it, like an appropriate risk assessment, like managing a SWIMS process when they're aware it's not working. So when they have a state of knowledge which is contrary to their body of knowledge and they have an accountability and responsibility and they don't act, we're starting to see regulators prosecute. Okay? And that's my fault. Sorry, guys, I meant to put the case in. There's only one major successful prosecution on this, but there is a number of other prosecutions in the flow that are about to happen to OHS managers, and it sits around, I have a responsibility operationally, I'm seized with a piece of knowledge that tells me there's something wrong, and I choose not to do something about it, or I acquiesce with the management view, look, we just don't want to do that, when you're doing something that places someone's life at risk. Okay? So let's go on to the case study.
Relevant to our case study.
Yeah.
Strap yourselves in.
This is a long one. I wrote this morning, guys. I'll just take a break and a smoke outside. No, that's right. Off you go, Kim.
All right. I really need to get new glasses too. Bleensfield Grammar, or BG, had 1,300 students. It was a school centred around sport and had an internal elite sports academy that engaged coaches as casuals or as contractors. The two sports it focused on were basketball and rowing. Its teams and crews dominated in national titles, and the academy had direct links to US-based university programs.
I think BS is bullshit. Yeah, no, I've got to be caught up and say it's going to be BG. BS is good, isn't it?
At 5 o'clock in the morning. BG offered a variety of scholarships from full fee to part fee. Oh, Steve, you want to be quick?
Part fee paying. There you go.
It was notorious within the school that the children in the academy commonly had very driven parents who did not respect the common school boundaries as they motivated and drove their children for sporting success and recognition. On 12 November 22, the head coach, Terry, a full-time position, was he licking your ankle at that time?
Probably.
Met with the principal, Madge, of the school and the chief people officer, Campbell, to plan for 2023. Campbell had responsibilities for all people-related issues, including safety.
Let me do a couple, because this is a long one. Terry explained the coaching group would need to be expanded to include a conditioning coach and an exercise physiologist. He would also need all staff to increase their hours by around about 10%. He wanted the new roles to be contractors and explained he would need them on a regular basis throughout the year. He raised issues with his budget and how the 10% extra would be managed. 70% of the staff were contractors. Their hours varied based on seasonal requirements, but they were working long hours, over 38 hours a week, and were paid flat rates around $5 an hour over the general award. All coaching staff were required to attend a strategy week each year in January that was unpaid. The strategy week was an in-house session at BG's at the Grammars Beach campus with accommodation and food provided. He developed the elite program for the following year and honed how each coaching and staff support would work together and deliver the best results. Finally, Terry raised the vexed and constant problem of parental misconduct, which included offensive, abusive emails and messages sent at all hours of the day and night, and at times included misconducted events and training by parents. There had been 2 occasions where this escalated into physical contact with coaching staff, once grabbing by the arm and shouting at the coach, and another striking the coach in the chest with a forefinger to make a point. I'm a bit like that sometimes. I do that sort of stuff. Madge and Campbell responded in the following way. Campbell explained that some of the roles were clearly full or part-time roles. Now remember, Campbell was the HR manager effectively. Part-time roles and should be remunerated that way. He tabled a spreadsheet that showed despite the higher than award hourly rate, because much of the work was weekend work and several did more than 38 hours, both penalties and overtime applied to the casuals. He explained why the contractors run questioning employees. None of the contractors ran their own business, couldn't delegate their work and used no personal assets. Their roles were closely managed by Terry. In other words, the control test underwater as a contractor, how you do it, what you do, was managed by Terry. He went on to say that the unpaid strategy week was work week and should have been paid. Terry said he would need more budget. Madge said they didn't have it. She explained it was a scholarship program and that few paid full fees. They agreed to develop a package that showed staff were better off and focus on how it advanced their career in sport. Many of them had gone on to roles in elite sport. And Campbell would manage payroll figures to ensure the review would demonstrate all were paid in accordance with the award. Madge asked Campbell about what controls they can use for the parental behaviour. Now remember, Campbell was the Chief People Officer, but also responsible for safety. Campbell said he had managed several cases of staff concerns, including 2 accepted stress-related workers' comp claims for the casuals, and 3 coaches who were contractors last year resigned because of parental behaviour.
Okay.
Yeah, you go. Come on.
He had added a parents' induction night, a new parental code of conduct, and said they would step up the management of parents to give a few examples. Madge asked, had he done any form of risk assessment? Both Terry and Campbell said they started one, but soon realised the problems were intractable and the issues were too hard to stop. All coaches knew not to respond to direct emails or messages. Terry did that. Any direct behaviour, Terry would talk with the parents, send letters and the like. Campbell made it clear if he completed the assessment, he was creating liability for the school because seeking to control the risks that attached to the hazards would cause huge parental and board problems, with the major 2 offenders being the chair and the treasurer of the board, both ex-Olympians. Madge nodded and said, best to let sleeping dogs lie.
That's Terry again. That was my dog.
At the Intergrammar basketball final, BG boys team lost, with the opponents nailing a 3-pointer in the last 4 seconds to win by 1 point. The chair was furious. He came down from the stand, abused the student playing guard, who said he should have stopped the shot, calling him an effing idiot, grabbed his arm and lifting him up to show what to do. He then turned on the coach, shouting and screaming in an abusive manner what a fool she was and how she didn't know shit from play. I can say that.
Interesting.
He wrenched his son away from the other players and left the stadium loudly criticising the other players and coach. Throughout the night, he unleashed a torrent of abusive emails and texts to the coach, Jenny, an ex-NBA captain. Jenny rang Madge at 9 p.m, 4 hours after the game was over. She cried throughout the call and was obviously very distressed. She explained what was happening and Madge said to turn off her phone, not read the emails, and Madge would speak to the chair early the next day and fix things.
My turn. Jenny was distraught, felt alone, had a few stiff drinks to numb the hurt, and arranged to meet colleagues across the road at a bar at 10:30. At 10:35, she went to wander across the road to the bar. By that time, she'd consumed a third of a bottle of vodka, was unaware how drunk she was, and was still distressed and distracted by what had happened. As she stepped out from behind a parked car, she was struck by an oncoming truck, suffering fatal injuries.
On the day it was a third of a bottle, when I was reading it in the car, driving in, I thought it was a third bottle. I thought,
no, that was me last night. Yeah. Okay, so were the contractors really employees? So we're now faced with a change in the law that goes back to the old multifactorial test.
Yeah.
The key issue is control. Okay, in other words, if if Terry told you to do this job and you had a program and you had to do it his way, that's control.
Yeah.
But the inability to delegate, the lack of assets, they weren't using own vehicles or doing things, all those things suggest unquestionably they were employees. Some of them were clearly permanent employees, some of them were casual employees. This is a real problem, and yet it's very, very common when people see someone who's not a mainstream teacher, whether it's a grounds person, whether it's somebody else who's itinerant or working around the organisation, they go, why don't we just take him on as a contractor? Big mistake. And then the rules of what an employee is attached to it. No leave, none of those things. So this is not only were they contractors, but this was sham contracting, which caused financial harm. So it brings us probably to the next question, which is, who could be prosecuted for underpayment of wages and failure to accrue and pay entitlements like overtime, penalties, annual leave and long service leave? The difficulty with this is, Kim, every one of them could be prosecuted. I'll start that, but not just prosecuted by the federal prosecutor, but by the state prosecutor for long service leave. Okay. So this is pretty naughty because casuals do accrue long service leave, but contractors don't. And what's happened here is a device that's been used, maybe not intentionally understanding the effect of it, but I think probably, which means you've got two, both of which have jail sentences that attach them independently, both of which fall into different jurisdictions. So the answer is school is terribly liable. They're going to be paying back with penalties and interest, very substantial penalties and interest. The HR manager in huge trouble for falsifying records. The school principal is in deep trouble for refusing resources and budgets. And Terry's going along with it, probably not understanding nor completely knowing it, if that's what he pleaded, would leave him down the bottom. But these are fines for the HR manager of more than $50,000 to $60,000 under just the federal legislation. So we could have someone going to jail for this very, very easy because it's pure wage theft. Okay. All right. Could the chair face prosecution under the safety law, and if so, what? Now, why did I ask that? Well, because under the general duties, other people can't be liable in Victoria, but they certainly can be under reckless endangerment because the definition of who is liable is a person. And could the chair be liable under 144 as an officer? Absolutely, because the chair knew the behaviour, because they were doing the behaviour, could cause harm. So in Victoria, they have the subjective knowledge. They're liable here under Section 27, Work Health and Safety. Everywhere else in Australia, definitely liable. The chair is in a lot of trouble because he could have caused serious harm or death, which is the slightly different test that exists across the jurisdictions. Not only was he careless, he was deliberate. So that's reckless endangerment, but it's moving closely towards industrial manslaughter because although the death happened outside of work, that's not part of industrial manslaughter or workplace manslaughter as they call it in Australia. So he could be going to jail.
Does the death have to be foreseeable from the conduct?
Yes, because it has to be the substantial cause of it.
Right.
Yeah. I think so. This is such a good question because in a way it is foreseeable. If I treat you horrendously, if I barrage you with things, I've got to expect there is conduct that comes out the back end. And I've got to understand, not knowing you, that there is a likelihood it's going to cause mental health issues. And those could range from becoming depressed to doing something much sadder. So the fact of the nature of the accident doesn't have to be foreseeable. It's the risk that has to be foreseeable. Okay, so great question. Okay, could the school and MADs be prosecuted under safety law and what for? Well, they're employees, okay, so they can be Section 25 breaches, not done or exercise reasonable care, bring risk to another person. Yep. They've got that liability. MADG is definitely an officer, so Section 144. And at that stage, I'm afraid it's got a bit worse because they really are on the path to reckless endangerment because they know of the specific risk that does exist and they've chosen not to do something about it. So they're off to reckless endangerment land and they would be charged. If we look at the Victorian Building Authority case, where people knew of a specific risk in performance management and restructuring, much lower set of facts than what occurred here. They're in real strife. Was Campbell at risk under safety law? No one could be more at risk than him, the person who had the body of knowledge, who started doing a risk assessment and walked away from it because it might create liability. And yes, could have looked and worked out how to manage these and knew that it was their own officers who were the major problem. So what could have they done? I tell you what, if I was Campbell, I would have brought in WorkSafe the moment I started doing the risk assessment and say, look, we need some education and help around this issue. Not to give them all the evidence, so they're going to go and prosecute you, but you've got to scare the shit out of them somehow, don't you? You've got to start the process. And I'd bring WorkSafe along to talk to the parent group. That'd be a start. Why? Because then when I roll out a code of conduct, and it would say, look, behaviour like this will lead to your child being exited from the program, it won't happen because this is everything. So there's an easy way through this. So look, fun. Of course, it's lovely having you along. You notice in the case study I didn't put in words you can't pronounce, which I do to Nina every week. Because I knew you'd be trembling.
Well,
I didn't want to do it.
I trip over the most simple words anyway.
Now look, we've got some exciting news too, just before we jump off. All pain, no gain. It's happening. Okay, the legislation's come through. We'd love to talk to you. It's now on in a bigger premises, still in here, still in our office, but downstairs. Come along. We've got about 5 or 6 on a waiting list, but I think we've still got a little bit of room, so please jump in now. And can you give Kim a thumbs up for turning up and doing this today? Here's cheers, guys.
I'll be back next week.
See you then. Bye-bye.
Bye.